In this lecture, we will discuss about Article 10. Article 10 talks about how personal information related to the criminal records and offences is treated under GDPR. Only under two circumstances, processing of personal data about someone's criminal offences is allowed. First one, when processing takes place under the control of an authorized officer, or when there is a specific law that permits this, and it includes protection for the rights and privacy of the individual. Let's say there is a police department responsible for maintaining criminal records. According to Article 10, they can process and keep records of criminal convictions because they are an official authority. However, if a private company, like an insurance company, wants to access someone's criminal record, they can only do so if there is a specific law that allows this and it also protects the person's right. Also, Article 10 says that register for criminal conviction shall be kept only under the control of an official authority. Let us recap Article 10 by way of multiple choice questions. Let us discuss the first question. Under what conditions can the processing of personal data relating to criminal convictions and offences be carried out? Correct answer is option B. Only under the control of official authority and when it is authorized by union or member state law. This is as per requirement of Article 10. Also, register for such record shall be kept only under the control of official authority. Let us discuss the next question. In what cases can a comprehensive register of criminal convictions be kept? Correct answer is option B. Only under the control of official authority. This is as per requirement of Article 10. It says that register should be kept under the control of official authority. That's all for this lecture. Thanks for watching.